Then we ask ourselves, which documents would be required in forming a company? So the procedures to be followed by persons who intend to form a registered company will depend on whether the proposed company is to be a public company or a private company. You remember when we were discussing the nature and classifications of companies, we talked about a public company and a private company. So for a public company, the initial step must be taken by promoters. You prepare a document, you as the promoter, you prepare a document called the Memorandum of Association, in which at least 7 of these individuals subscribe their names as prescribed in Section 4 of the Companies Act. Section 4 provides that in the case of a company having a share capital, the memorandum shall also, unless the company is an unlimited company, state the amount of share capital with which the company proposes to be registered and the division thereof into shares of a fixed amount. And it also provides that no subscriber of the memorandum shall take less than 1 share. And finally, that is Section 5. Section 4, in Part 2 of the Incorporation of Companies and Matters Incidental thereto, provides that any 7 or more persons, or where the company to be formed will be a private company, any 2 or more persons associated. So for a public company, as we discussed earlier, we'll need a minimum of 7. For a private company, a minimum of 2. You subscribe, the 7 of you, or the 2 of you, in the instance of a private company, you subscribe your names into a Memorandum of Association, and as provided in the Act, you either have the liability limited by the memorandum to the amount, if any, unpaid, or you can have a company not limited on the liability of its members. The memorandum must contain a declaration by the promoters that they are desirous of being formed into a company pursuant, and therefore must state the name of the company with limited as the last word of the company in case of a company limited by shares or by guarantee. The registered office must be situated in Kenya. You must also name the objects of the company. Why are you forming the company? Which business do you intend to transact in? You must also indicate the amount of capital within which the company is to be registered and the division of capital into shares of a fixed amount. So the memorandum of a company limited by shares or guarantee must state that the liability of the company's members is limited. For that limited by guarantee, also states the amount guaranteed by each member of the company. This means how much are you willing to put up, you that has decided to form and you whose names are appended in the Memorandum of Association. For limited by shares, how many shares have you subscribed to? With the memorandum providing each share, probably 1 share, if it's worth 100 shillings, you buy 500 shares, you multiply by the initial amount recorded, you are limited to that, meaning at any given time, should the company be wound up, you are liable to the extent of the amount unpaid on the shares that you bought. So once the memorandum is delivered to the Register of Companies, it is accompanied by the following documents as well. One is the Articles of Association. The Articles of Association contains the regulations for the management of the company. If the proposed company is to be limited by shares, then the promoters need not deliver it for registration. In this, we rely on the provisions of Part 1 of Table A in the first schedule to the Act, and therefore will automatically be applicable to the company under Section 2 of the Companies Act if the promoters do not deliver it. Section 2 of the Section 2 of the Act provides Section 2 of the Act provides the interpretation that gives the terms, the phrases used in the Act. Articles means the articles of association of a company as originally framed or altered. Also provides a company, the definition of the word company. So Table A in the first schedule provides as follows. I will share the table later if we can proceed. What also needs to be accompanied is the consent to act as director. What does this form number 209 provide? That if any person is appointed director of the company under the articles which are to be delivered, form number 209 must be delivered for registration. And this form, it's the statutory significations of the person's consent to act as a director. Once your name is endorsed, and once this form is taken to is delivered, because you must sign it, it must not only be completed, it must also be signed, or you appoint an agent in writing to do that for you. It binds you that you are aware of what is of the articles of association, you agree with them, and you have agreed to become a director of this company. This is the Form 209. It is a consent to act as a director of a company, as read with Section 182(1)(a) of the Companies Act. It has the name of the company presented by and to the Registrar of Companies, whereby it says, I or we testify to our consent to act as a director of your company, pursuant to Section 182(1)(a) of the Companies Act. It provides the signature, the address, and the description. It is dated. The fee may have changed. And as we were saying, if a director signs by his agent authorized in writing, you can send someone to do it for you, but you must authorize it in writing. And before this Form 209 is accepted, that authority must be produced before anyone can sign on your behalf, because this is a consent. Ideally, you should do it individually. Where you're not able to do it, then you send someone in writing and they act on your behalf. We also have the list of persons who have consented to be directors, and that is Form 210. You remember we are talking about the documents required to form the company. These forms are in the Companies Act. They're the regulations that have been set out before you proceed to act or to transact in any business. Not only must you register your articles of association and memorandum of association, these forms are mandatory. You cannot proceed to act without filing these forms with the Registrar of Companies. We talked about Form 209. You as an individual, you have consented. We go ahead and talk about Form number 210, which is a list of persons who have consented to be directors of the company. It also provides the same, the name of the company presented by, and these are the lists, read with Section 182(4) of the Companies Act. Your names are provided. It is also signed. The statement of the nominal share capital is also provided, and this is for taxation purposes, pursuant to Section 39 of the Stamp Duty Act. We also attach Form number 208, and this, when duly completed and signed, constitutes the statutory declaration by the advocate engaged in the formation of the proposed company, or by the person named in the articles as a director or secretary of the company, that all the requirements of the Companies Act in respect of matters precedent to the registration of the company and incidental thereto have been complied with. This is Form number 208. It's a declaration of compliance with the requirements of the Companies Act on application for registration of a company. Remember, this one is not signed by the directors. It is signed by the advocate engaged in the formation of the proposed company. And it is signed before a commissioner for oaths. It is a statutory declaration that every requirement listed out in the Companies Act has been followed and complied with. See, it says that I make this declaration believing the same to be true and according to the Oaths and Statutory Declarations Act. In essence, it means that whoever provides this declaration, Form number 208, and signs, acts believing that all the requirements set out in the Companies Act in the formation of a company have been complied with to the letter. So finally, if all these documents are in order, the registrar will then grant a certificate of incorporation, and the company is formed from the date of incorporation written in the certificate. From the date written as per Section 16, the company now comes into existence, and it has a separate legal entity. It can sue and be sued on its own. It can own property, and it outlives the founders or the shares. It has no, how a company is dissolved is provided for in the Articles and Memorandum of Association. That was the formation of a public company. So for a private company, we follow the same procedure, only that the memorandum will be signed by at least 2 of the company's promoters. And in the private company, we do not have the Form 209 and Form 210 delivered for registration, because Section 182(5) exempts the promoters of a private company from the obligation to deliver them for registration. Again, we talk about the differences between a private company and a public company. And we have seen that the documents required for the registration of a public company, they are more, because these forms, it cannot be registered without the Form number 210 and Form number 209. For a private company, they're exempted according to Section 182(5). We go to the provisions of Section 182 so that you're able to understand the differences in a public and private company as provided for in the Act during the registration. We'll now talk about the constitutive documents, and these are the constitution of a company. It is basically the Memorandum and Articles of Association. So in relation to companies registered under the Companies Act, a Memorandum of Association was judicially defined by Lord Keynes in Ashbury Railway Carriage Company versus Rich as the charter, which defines the limitation of the powers of a company to be established under the Act. The memorandum is the document that contains the fundamental rules that regard the constitution and activities of a company. This is the basic document that lays down how the company is to be constituted and what work it shall undertake. So what is its work? It enables the members, the creditors, and the public at large to know, why is this company in existence? What does it do? What is it purporting to do? To what extent? The range of its activities. It also contains the rules regarding the capital structure, the liability of the members as we have provided, the objects of the company, and all other important matters relating to the company. It is only altered after certain formalities are observed. This Memorandum of Association is the reason why the company exists. That if today I form a company with the intention of importing goods across East Africa, it will be listed in the Memorandum of Association that the reason as to why this company is in existence is to move goods from country A to country B. And in so doing, it has set up the structure to enable it to do so. So why do we need the Memorandum of Association? It shows the range of the enterprise. It is the foundation. It is the superstructure of the company. It enables the shareholders, the creditors, and outsiders to show the permitted activities of the company. So what are the form and contents of the memorandum? They are prescribed by Section 5 of the Companies Act, and they contain 1, the name clause, the name of the company with the word limited at the end of the name of a public company, and private limited for a private company. And then the registered office clause. It must contain the state in which the registered office of the company is to be situated. If I intend to have my domain business in Nairobi, the memorandum must contain where in Nairobi. You cannot, we have, if it's a post office box, there are different codes. You cannot be vague. It needs to contain where the offices are located, the street, the building, the part of the town. All these are required. Thirdly, the Memorandum of Association contains the objects clause. What do we mean by this? This is the main object and objects incidental and ancillary to the main objects and other objects not included. We talked about forming a company for the importation of goods from Nairobi to Kampala. So the objects of the memorandum will clearly state that this company is formed A, to permit the movement of goods. But which goods are we talking about? We can go ahead and define agricultural goods, commercial goods, as well as industrial goods. This is where this company is being formed. We also talk about, that is the main object of the company. But we can also talk about, not only are we importing, we're also providing transport services in as far as what we have set up to do is allowed. We also have in the Memorandum of Association the limitation of liability cause. What does this one do? It states the nature of the liabilities, whether it is limited by shares or by guarantee, or it is unlimited. If it's limited by shares, we have talked about this, to the extent of which your shares remain unpaid, by guarantee, as is stated, or whether it is unlimited. So in the memorandum, we also have the capital clause. This is in case of a company having share capital, unless the company is an unlimited company. The memorandum states the amount of share capital and the division thereof into shares of a fixed amount, whereby we can decide we are starting our company with 100 shares, and each share is equal to 1,000 shillings. So it is limited to that. We lastly have the association clause. So what do we mean by this? No subscriber to the memorandum shall take less than one share, and each subscriber shall write opposite to his name the number of shares he takes. It's a document that shows how many shares you have taken, and you write your name against the number of shares, so that in future no one can come up again and say you did not do ABCD. We have seen the forms that will be delivered to the Register of Companies, and which is why they insist that if you're not doing it in person, if you're authorizing someone else to do it for you, let the authority be in writing. Why do we do this? These are documents that will be made public. Once these documents are made public, that consent for you to be a director, it will be available to anyone who seeks to know what business are you practicing? What do you intend to do now that you have formed this company? Whether limited by guarantee, limited by share, limited or unlimited, these documents are available for perusal. So any individual can come and look at them. He can also see how many shares are available, were made during the incorporation of this company, and each share, how much is it worth? And on top of that, who has taken these shares? Their name is inscribed against the number of shares taken. I would like to ask if there are any questions before we proceed to the rules regarding the names of companies. You are able to unmute yourself, or you can use the chat option. So any questions, any clarifications, any comments for the memorandum and articles of association, as well as the pre-incorporation contracts? Lincoln, your question is, can the company resolve to reduce the number of shares available? We have talked about the process of registering the company. And once the memorandum is provided to the Registrar of Companies, it also provides what you can, as you are asking about the number of shares available. That memorandum will provide the procedure on how to reduce the number of shares available. Again, depending on whether it is a private company or a public company. The memorandum that you'll provide is the constitution of your company. It gives you the laws, the rules, and in it, you can put whatever you believe is necessary. There are no right or wrong ways to do a memorandum. Remember, the Act only provides the bare minimum that the memorandum must be provided. What we have done is the bare minimum. When we say what are the contents of the memorandum, we have listed what is provided in the Act, that it has the name of the company, it has the registered office, it has the objects clause, which says why the company is being formed, it has the limitation of liability, it has the capital clause, and in this capital clause is where the members, the owners of that company would include that the shares can be reduced or added. We also have the association clause. You understand that these are the bare minimums as provided for in the Act. The Act does not limit you to what you can provide in the memorandum or articles. It only provides that you must not engage in illegal business. Whatever you provide in these memorandum and articles of association must be within the law. And if you resolve to reduce the number of shares available, you must have provided for that in that incorporation document. You cannot come up in future and go against what is in your memorandum and articles of association. I hope I have answered your question. Remember, the main case is the Ashbury Railway Carriage, and it says that the memorandum is the charter, and it defines the limitation of the powers of a company to be established. It contains the fundamental rules regarding the constitution and activities. It's the basic document which lays down how the company is to be constituted and what work it shall undertake. You see, the purpose of the memorandum is to enable the members, its creditors, and the public to know what its powers are and the range of activities. It can be altered, as you're asking, but after certain formalities are observed. It is not as easy as today you take this memorandum, tomorrow you change it. This basic document provides how the company will be run, and in it provides also whether shares can be reduced or added. I hope I have answered your question, Mwangi.